today in the session. Today with us we have Mr. Vijay Shankar. He's also called as the Naavi. He's one of the techno-legal consultant in the cyberspace. He's also chairman of Foundation for Data Protection Professionals in India. He has been with this industry over last 30 plus years. He has been consulting to many organizations in case of any legal issues of cybercrime and also helping organizations to define their privacy and protection programs. So this is the overall agenda we have today. Again, I would like to welcome all of you to the session. With this, setting up this context, I wish to hand it over to Mr. Naavi. Welcome, Mr. Naavi. Please go ahead.
Good morning, friends. It is nice to be with this August group to discuss a topic which I'm sure many of you are familiar. Actually, we are discussing DPIA with specific reference to the Indian Data Protection Regulation, which could be the new bill which the government is dilly-dallying and pushing it from session to session. It is called DPDPB 2022. Now we are already in 23, so it will become DPDPB 2023. Of course, the ministers are assuring that this will be presented in the next monsoon session starting somewhere in July. And hopefully it will be going through. Now, as of now, DPDPB 2022, which is the bill which was released for public comments, becomes a sort of a legislative intent declared by the government. And therefore, it should be looked at as the best practice or due diligence, which is part of our current data protection law, which is Information Technology Act 2000, which under section 43 capital A talks of reasonable security practices. And that reasonable security practice is inclusive of what we call as due diligence. And due diligence is the ability to understand the requirements of the environment and implement it, even if it is not set in terms of a particular act. Therefore, I consider DPDPB 2022 as part of the due diligence extension of 43A of Information Technology Act. To that extent, I say that this obligation can be considered as current obligation of the industry. We don't have to wait for the act to become fully operational. When it becomes fully operational, of course, the regulatory agencies under this new act will come into being and certain refinements will be implemented. So that's the context in which I would like to discuss the concept of DPIA. First, we will discuss the general concept of DPIA and then look at the different laws, how they look at DPIA, and then specifically look at the DPDPB 2022 risks, because risk assessment is a very important part of any DPIA. Then we will briefly look at what kind of framework which we can use for such risk assessment, and we will spend time on discussions. In order to actually set the context for the whole process, I have tried to actually visualize a sort of a case so that all of you can have this in the back of your mind, so that when we discuss various aspects, you can relate it to this particular thing. This is a typical case where I am looking at a company I have tentatively named as Divya Drishti, a company established in London, which maintains a website, divyadrishti.ind.in, which is hosted on a Chennai-based web hosting company, Triads Private Limited, which uses the hosting server of a company in France. This is a very typical way a website gets established. Now, this Divya Drishti is a data engineering company and provides products and services for marketing. Now, both digitally and also in terms of paper-based reports or insights. Part of its market intelligence and data acquisition strategy, it offers download of valuable materials, which could be scientific reports, business information, educational videos, and so many other things, both for payment and free, to persons who make a request through a particular form in the site. Now, this web form collects personal information such as name, gender, email address, mobile number, and so on. And generally, the distribution of users is 70% from India, 15% from EU region, the rest from US and other areas. All these are important for our DPIA kind of a discussion. Now, a situation has arisen as part of the IPL promotion activity. A proposal has been made by the marketing team of the company to offer some special prizes each day to a lucky downloader, for which it needs to collect the information of banking and PayPal information, to which credits can be given. It also proposes to use an AI algorithm to determine the winner based on the nature of downloads. This is the case. In fact, Cred currently runs such a campaign on IPL. So this perhaps is something similar. So let us keep this case study back of our mind. It will help us focus on the various aspects. Towards the end of the presentation, if time permits, we will discuss this specifically. Now, before we proceed, let us clarify the terminology of DPIA. Now, one of the terms which are similar is the private impact assessment. Then you can call the DPIA as data privacy impact assessment as well as data protection impact assessment. As long as we understand what we are doing, the terminology differentiation is not very relevant. But to be little more, clear, we can say privacy impact assessment is an assessment of the impact of an action of a company on the privacy rights of the data subject. The privacy rights of the data subject is something which is actually a human rights kind of a concept. It is not necessarily the IT concept. But when there is a possibility that privacy right could be infringed with the use of personal information, which is data, this privacy impact assessment translates into a need of the IT industry. There we are looking at these two concepts of data privacy impact and data protection impact. For our discussions, we will recognize data privacy impact as the impact on the privacy of individuals from the enterprise level activities, whereas DPIA specifically, we will look at a single process or a set of few processes and look at the impact on privacy arising out of this this particular process or one or two connected processes. Now, why do we need DPIA? That is one. All kinds of data protection is integral to the quality of service, and it is a best practice. The reason is that every product or service should be not only functional, but also safe for the user. So that's why it's becoming a best practice. Now, data privacy is not limited to only the CIA concept, that is the confidentiality of data, but it extends to the protection of the privacy of an individual, whoever is exposed to the service or the product. This is a techno-legal proposition, and the individuals exposed to this product or service could be employees, could be outsiders. Now, DPIA specifically, if you look at that term, is an action mandated by law, and it could result in a liability if it is ignored. So that is the, you can say, the crux of our discussion. We are looking at DPIA, which is a prescription of law, and therefore it is a risk to be mitigated, because any failure would perhaps result in some kind of a liability. In the case of the GDPR, we are talking of the 4% global turnover as the limit up to which liabilities can come. In the case of the Indian law, we are talking of a maximum of 500 crores. But this 500 crores could be multiplied by a number of instances on which the particular company has perhaps been held liable on different, say, non-compliance issues. Maybe India may adopt something like in HIPAA, there is a similar provision that there is a category limitation, US dollars 0.5 million. But if there are more than one kind of violation, it can be 1.5 millions plus 1.5, something like that. So India also may adopt, so that there could be exceptional cases where the liabilities could exceed 500 crores. But normally we can say that the current thinking, the maximum penalty is up to 500 crores. It is not based on turnover. It will be based on forms of assessment. Now, when DPIA is conducted across all processes in an organization, that aggregates into the compliance requirement at the enterprise level. You can call that as privacy by default or compliance by default, whatever way. So enterprise level compliance is an aggregation of the DPIAs of individual processes. But many times when something new is being done, we need to look at DPIA exclusively on one single process. So what we are looking at DPIA is for privacy protection, DPIA for data protection. If you look at, then it may include both personal and non-personal data, covering CIA principle. It is more or less the information security aspect. DPIA for data privacy is inclusive of assessment of the CIA risk, confidentiality, integrity, risk, applied to the personal data. Now, DPIA for privacy protection is an assessment of risk on privacy right infringement and is dictated by the law. This is slightly broader than the coverage of CIA risk on personal data. CIA risk on personal data is only a technical control management as far as the confidentiality, integrity, and availability of personal data is concerned. But when we talk of privacy protection, we have got something more to be added. That is why the role of a data protection officer is broader than that of a CISO in terms of the type of activities, though the amount of data which comes under the scope of DPO could be less than what comes under CISO, because CISO will look at, let us say, security of both personal and non-personal data. That is what he has been doing right now. Now, when DPOs come into the organization, DPOs will be told, you please look at the personal data related issues, which should cover not only the CIA aspect, which CISO was hitherto handling, plus certain other things which the privacy law expects you. So that is how perhaps the segregation of duties will happen between CISO and the DPO in the days to come. Now, risk assessment, when we talk of, includes risk management. That is, we identify the risk, then we look at mitigating the risk, and sometimes we may look at transfer of the risk by way of insurance, and then we, as a management, take a decision to absorb, and what remains is the residual risk. Therefore, it's an overall risk, which is the risk at level 1. Then part of it is mitigated because of our efforts. That gives a residual risk at level 2. Then this is further reduced because we take some cyber insurance, which may not cover the entire risk anyway. Therefore, it becomes a residual risk at 3. Beyond this, there is always some kind of risk which the management says that I will not insure, I will not mitigate, I will absorb it because I have the capacity to absorb this particular risk. So when we talk of a risk assessment for a DPIA, we must be aware of what is the risk appetite of my organization, what is my CFO's capability as far as the purchase of a cyber insurance is concerned, what is the capability of my technical department for introducing technical controls for mitigating. Then I will be able to say that this is the residual risk which comes under DPIA, which the privacy officer or the DPO will try to address through policy and other things and try to mitigate as much as possible. So this is how I look at the scope of this risk assessment, inclusive of the certain decisions which are beyond that of the DPO, beyond that of the CISO. It lies only in the board. For it is something which only the board can decide. Now, DPIA as PIA, that is Privacy Impact Assessment, obviously requires an understanding of the law. This is where the technology people need to actually take some efforts to understand the law, because the concept of privacy is a legal concept. It is a human rights concept. We are not talking of privacy here as confidentiality of data, which can be, for example, addressed through only, say, encryption and say access control, which are required even under privacy. But privacy has got something more, because the law defines privacy in a very vague manner. Even our Supreme Court was not able to define privacy, even though 9 judges sat in the Puttaswamy judgment. Ultimately, they gave some kind of an explanation saying that privacy could be what a person eats, what a person does, where does he go, all these things. They all actually confuse the implementers as to what exactly is the right. But ultimately, we have tried to say converge on the right to privacy as a right of choice which an individual can express about how his personal data can be shared. Ultimately, the right of privacy comes down to that, and in the IT environment, I have to see what is the personal information which XYZ is willing to share with me. What does he allow me to do with it? That is what is called the right to privacy. Right to privacy becomes a right of choice as expressed by an individual. So that's why this becomes a sort of an analysis of the data protection law. So the context has to be set in the applicability of law, which also depends on the jurisdictional impact. For example, GDPR may have a jurisdiction, Indian law may have a different jurisdiction. Now I have to set the scope based on the jurisdictional impact of a given law. Sometimes, because technology actually collects information from different jurisdictions, because we say internet is borderless, the applicability of law becomes overlapping. That is, every company today which has got a website will have a mix of data, part of that coming from India, part of it coming from EU, part of it coming from elsewhere, and privacy laws in each of the countries are different. Therefore, we always have a overlapping position as far as law is concerned. And if we say DPIA requires this understanding, it means it requires understanding of multiple laws, as many countries' laws as the data which you are having. Now, therefore, before even we look at the scope definition, it becomes very necessary for us to segregate the data. How much of data is having the jurisdictional impact from the Indian law? How much comes from EU? That is where, in the case study, I was mentioning that out of the data subject, 70% comes from India, 15% comes from elsewhere. That, in a way, defines that 70% of the data could have an impact of Indian DPB, whereas that the 15% will not have DPB impact. It will have GDPR impact, or perhaps some way a combination of the two. So this is where the identification of jurisdiction and segregation of data becomes more or less a pre-assessment step, or for something required for scope definition before we embark on risk assessment, then probability of occurrence, and then impact estimation. If you look at risk assessment as consisting of assessment of risk, probability of occurrence, and impact, that will have to come with reference to part of the data with reference to the Indian law, part of the data with reference to some other law. So that segregation of data and understanding that different data sets are exposed to different laws becomes integral to the conduct of the DPIA. Now, for example, if you are having a new process and the new process is only addressing, let us say, collection of data from EU, then probably only GDPR is relevant for that DPIA. Whereas if you are having a new process which you are putting, let us say, in Singapore, maybe Singapore law is relevant for that particular thing. If you are putting the new process which is going to be located in India and the possibility of data coming in from India, then Indian law will be applicable. Now, if you have a single process which does all the collection from all these regions, then you are mixing up the whole data and making compliance complicated. In fact, DPIA, one of the risks could be the mixing up of the data. If you cannot segregate data, that becomes one of the biggest risks in DPIA, because whatever decision you take about the implementation of any control, there could be some kind of a differentiation between different laws. One glaring requirement could be handling of the minors data. Who is a minor in Indian law is different from who is a minor under, let us say, the Spanish law, may be different from a French law. So if I have one single assessment for minors, it is likely to fail in any one of the jurisdictions. Therefore, the segregation of data becomes an integral part of the risk assessment. Now, the other question which we have to ask ourselves is DPIA limited to the technology process only, or does it extend to the business process? Now, if you look at business process as a collection of activities meant to achieve a specified business goals, it may or may not include technology, because there could be some processes where I don't require technology at all. Let us say in employee onboarding, where I am conducting a personal face-to-face interview, I don't use technology, but that is also a process for onboarding, and there could be a risk there itself. The probability could be that you are interviewing a lady and you give some information which says that you are unlikely to be selected, and she starts crying before you. Probably that is a risk which you have to address. And what if she goes back and says that, no, I was harassed by this interviewer? Now, what is the kind of risk? That is, there is no technology. It's a human behavioral risk. So therefore, when you look at DPIA for a process, you must remember that it is possible that some processes may include technology, some processes may not include technology. In fact, the onboarding process may start with collecting information from email where technology is involved. It may involve, say, first interview on a Zoom meeting, which is also technology. Then third stage could be this personal interview where I said some kind of additional human behavioral kind of risks are there. So therefore, a DPIA, if you look at onboarding, employee onboarding process, you have to segregate into 2 or 3 sub-processes, and the overall DPIA, or the risk assessment for the whole process, may include the risk assessment for each of these sub-processes. That is where we say that DPIA could be a single process or a set of interconnected processes. That is the reason why the DPIA, when you are conducting, it is not possible for only one person to take care of all the assessments, risk assessments. You may have to ensure that the responsibility for DPIA is shared by multiple responsibility centers. In fact, those of you who have heard me speak about our PDPSI, that is a Personal Data Protection Standard of India, you are aware that we are insisting again and again that the contribution of responses from the company has to come from 5 different responsibility centers like the management, the IT, the law, the HR, and the DPO. We are not saying DPO will be the only person with whom I will conduct an interview and finalize a compliance requirement. We are talking of multiple responsibility centers, because risk can only be identified and mitigated by different people in the organization, and not all of them are in the technology department, not all of them are in the DPO department also. Now, if you look at law, GDPR as our main reference point, Article 35 talks about what is DPIA, when it is required, and what it should contain. So probably this becomes something like a foundation definition for DPIA. If you look at it from the point of understanding how should I proceed with DPIA. For example, this Article 35 says the requirement, when it is required. It says where a type of processing in particular is using new technologies and high risk, likely to result in high risk to the rights and freedoms of natural persons, then this DPIA is required. But while making the DPIA, you should take into account the nature, scope, context, and purposes of processing. This indicates that there has to be a risk assessment. And if the risk assessment is considered high, and if there is use of new technologies, then the controller shall, prior to processing, carry out the data protection impact assessment. And this Article 35 goes on to further explain that it is in particular required when there is a systematic and extensive evaluation of personal aspects where automated processing is involved, or special categories of data are involved, or a systematic monitoring of data or publicly available data which leads to profiling is involved. So special categories is the sensitive personal information which we are talking of. The new DPDPB does not actually specify list of sensitive personal information. It defines a category called significant data fiduciaries, different from ordinary data fiduciaries, but it doesn't specifically talk about sensitive personal information. It may tomorrow decide that I will call a particular organization significant data fiduciary because he processes, say, sensitive personal information of, say, your PAN card or something like that. So they may define sensitive personal information as part of the definition of significant data fiduciaries. Otherwise, as of now, the 30 section law does not contain a definition of sensitive personal information, though it is there in current section 43 capital A of Information Technology Act. It was also there in the earlier version of Data Protection Bill, which was called PDPB 2019 or DPA 2021. Those are the earlier names for this draft. So under Article 35, when new technologies are involved, high risk is involved. High risk to whom? Not to the company, high risk to the individuals whose data is being processed. That kind of a situation requires DPIA before the processing is commenced. And in particular, automated processing, special categories, and systematic profiling are the kind of situations where DPIA is essential. Now, GDPR also defines what should be the components of DPIA. This has been further expanded by ICO UK, which has given us a template, and it is better for us to know what is expected out of GDPR and the ICO UK's template about the components of a document called DPIA. One of the things is description of the processing of operations. So one has to describe what exactly we are processing, what categories of data is being processed here, how do we collect, what kind of third-party tools we use, and how the data is transferred. All these things become part of the description. Then details of the processing purpose, why we are processing, why is it necessary, is also part of the DPIA. Then there has to be an assessment of whether the processing is necessary and proportional to the purpose. This discussion becomes an important part of DPIA, because when you make the risk assessment has to be reviewed again and again to see whether this processing is relevant for a particular purpose, whether there are any alternative ways of achieving our purpose. If you can get it in some other manner, then you have to justify why that is not good. We are using only this kind of a process. And then we go into a detailed assessment of the risks to data subject rights. So assessing the risk is similar to what you do in the technology area, like you identify the threats, you identify the vulnerabilities. But here what you are trying to do is you are trying to address the threats and vulnerabilities with reference to the requirements of protecting the privacy of an individual as per the law. So there will be some difference between the technical approach to, say, threat modeling, and here the threats are completely different. Maybe whatever you do, technical, this thing is included here, but this has something more. Now, the security measures for reducing the risk is also part of DPIA, because you have to ultimately come at the residual risk part. That is, you make a principal assessment, which could be considered as gap assessment. Then you take into account the mitigation efforts, and then come at the residual risk. That is where I said that you may also have to take into account how much of risk is covered through insurance and other things. ICO UK has used the same set of prescriptions which has been given under GDPR, but they have put it in the form of a template, which is perhaps a little more prescriptive. I personally feel that these templates should be used only as a general guideline. Any person who is doing any techno-legal compliance should not be over-dependent on one template. Actually, they should actually look at every requirement from the perspective of the context, and then try to design his own template. But ICO UK has given a template which should definitely be taken into account for reference. It will also talk about the first para, which has to talk about identify the need for DPIA, then describe the processing, then describe what consultation process was adopted within the organization, then make an argument about the necessity and proportionality, and then go into identifying the risk, segregating it as likely, with likelihood of harm, remote, possible, probable, severity of harm, and overall risk. And then identify measures to reduce the risk and have a sign off of a responsible person. So this is the template, which is quite useful. But I would like you to understand each of these components before simply picking up that document and start filling up the respective areas or paragraphs. But it will help you when you go into the details of individual questions. A lot of at least you will not omit anything which is important. To that extent, you can make use of this template. You can apply this template where it is required to be compliant with the GDPR. Now, I have my own reservations in applying the same thing to the Indian law. It is better to either prepare a template here or have a totally zero-based approach. Now, the India earlier PDPB 2019 or the DPA for 2021, it actually specifically defined DPIA, and it gave more information like where significant data fiduciary intends to undertake a processing involving new technologies, large-scale profiling, and use of sensitive personal information, all the three parameters which are there in GDPR. The same thing was mentioned here, and any other processing which carries a risk of significant harm. So in a way, the requirements of GDPR was actually translated into PDPB 2019, but the current version of DPDPB 2022 does not at present in the Act give this detailed explanation. It simply says the significant data fiduciary shall undertake such other measures, including data protection impact assessment and periodic audit in relation to the objectives of this Act as may be prescribed. This is given as an additional obligation required from a significant data fiduciary. And it only gives an explanation that for the purpose of this Act, data protection impact assessment means a processing comprising of description, purpose, assessment of harm, measures for managing the risk of harm, and any other matter which will be prescribed. So you can say the DPIA under Indian law also will need to have a description, the purpose of processing, then the assessment of harm takes into account all aspects of the threats, vulnerabilities, risk, but you have to look at what is a harm. Harm is to the individuals whose personal data is part of the processing in this particular process for which we are conducting the DPIA. So if you keep that in mind, then you will know that DPIA under DPDPB 2022 will have in the minimum a description, purpose, assessment of harm, then measures for managing the risk. So assessment of harm and the mitigation efforts and arriving at a final residual risk is the crux of the DPIA. Now, all this is something which you should be aware before you actually look at the risks which are coming from this particular data protection bill. When you look at DPDPB 2022 risks, it requires some understanding of the Act. One thing we can say is, what is a risk under any law? That is an omission that could result in a penalty by the regulator. That is what we can call as a sort of risk. Now, omission could result in financial penalty. It could result financial penalty where the regulator collects the money and puts it into his kitty, like this Luxembourg supervisory authority wants to collect 800 million US dollars from Amazon and put it into its kitty because it is penalty. Now, Luxembourg is a country which I think population of less than 50 lakhs or something like that, but they want 800 million dollars as penalty. So that goes into the kitty of the regulator. That is one kind of penalty. The second kind of penalty is payment of a compensation to another individual who has suffered a loss. This is the normal way all laws try to protect the individuals. If we say law is to protect the privacy of an individual, when that individual has suffered a loss, he should be compensated to some extent financially, maybe by other means. So that could be another risk. Now, GDPR and DPDPB 2022 does not have do not have criminal provisions of putting a person in jail. In fact, PDP 2015 had at least one section in which that was possible. Here it is not there. But an omission of a provision of DPB 2022 or even GDPR could mean also a kind of a violation of some other criminal law. In India, we may say that there is Information Technology Act 2000 or IPC, and it is possible that GDPR, whatever omissions we are talking of, could also invoke one criminal law. Therefore, it is possible that criminal consequences can also hurt a company if one is not compliant with the DPDPB 2022, though the cause of action is not within this law, it is from another law. Now, DPIA is actually an attempt to mitigate or eliminate this risk of omission, which could lead to an adverse consequence on the company or sometimes its managers. Say some of these laws, for example, the penal laws in ITA 2000, as far as the civil compensation is concerned, the company can make the payment. But when it comes to criminal compensation, punishments, you cannot put a company in jail. Therefore, there are provisions in law which extend the criminal liability of an organization to the key executives of the organization. The key executive of the organization could be a person who is managing the business. It could be the DPO, it could be the CISO, we don't know, it could be the CEO or even the director. So this kind of provisions are there in some of the criminal provisions. We should be aware that omission of a data protection law, which also is a offense under some other law, could lead to very drastic consequences. So consciously, we should not think that DPDPB does not have a criminal this thing, so we don't bother. If ultimately a few crores payment is there, there is the company, we are big enough to take care of 100 crores, 200 crores. After all, internationally, GDPR penalties are 50 million, something like that, US dollars. In India, 500 crores is nothing. So this is what big tech companies will perhaps think. But when you see the possibility that an omission which is located under the data protection law could also be an offense under Information Technology Act, then you are exposing yourself to the criminal punishment of the CEO of the company. ITA 2000, for example, has got one provision which says diminishing the value of information residing in the computer could be an offense. Now, diminishing the value can happen because you have disclosed the information to people who are not supposed to receive it. So wrongful disclosure could be a privacy related offense, but it could also be an offense under Section 43 and Section 66 of Information Technology Act. It will have 3 years of imprisonment. So it's a cognizable offense. So let us not come to a kind of a conclusion that there is no criminal punishment in DPDPB, therefore I can do whatever I want. In the earlier version, the one section which was there, which involved criminal punishment, was the re-identification of a de-identified or anonymized information. So if I anonymize the information and disclose it, thinking that it is safe to disclose, there is no privacy infringement, but somebody says, I am an intelligent data engineer, data scientist, you give me any anonymized information, I have got tools to re-identify that. And if he does that, then he is liable under, he was liable under the earlier data protection law for criminal punishment. Today, the same punishment may come not from DPDPB 2022, but from ITA 2000, where we can say that the anonymized information had a certain value. You diminish that value by identifying it and causing a damage. So under multiple sections of Information Technology Act, offenses could be recognized. Some of them may be criminal offenses. So that is one thing I want all the technology people to remember, that DPIA can not only protect you from the 4% penalty or 500 crores penalty, it can also prevent you from being held liable for some criminal offenses. Because if you conduct a DPIA, it doesn't mean that no data breach is going to happen. Data breach may still happen, but conducting of a DPIA, documenting it properly, indicates that in good faith, you have taken some measures to reduce the risk. If that has not materialized, there could be various reasons for that. But not conducting a DPIA when it was ought to have been conducted means you have been negligent and reckless in reasonable security practices. In fact, our Information Technology Act has got one section called Section 43, subsection small g, 43G, which says that any person who assists another person in contravening the law will also be punishable. So a person can provide that assistance by not adopting proper security measures. I don't close the door properly, a thief comes in and steals something. The person who failed to close the door properly will be considered as a person who has assisted the person who actually stole. That is the law in India. Therefore, if you have not even made an assessment, what is DPIA? DPIA is like going and checking whether the door is locked or not, okay, or whether the lock is proper. Now, if that you have not done, there is a negligence that could perhaps result in its own liability. So that is something which I would like to mention. Around 10:30, we will have a small break. But before that, I will just go through a few more slides just to give you an umbrella kind of information on broad types of risks. One I consider as a risk is an ignorance risk. That is an organization not knowing what is their exposure to risk. So this is the fundamental aspect. Today, we are in a situation where a lot of companies have this ignorance risk. And to get over this risk, we need to do a gap assessment. And this gap assessment can be done as soon as possible, even before the law comes into existence, because the broad contours of the law we know. So a gap assessment will identify that. When you come to the actual controls and writing of the policies, if tomorrow in the monsoon session, if some changes are made, we can always incorporate that if we have already done a gap assessment based on the current law. Because you know that any data protection implementation is not an overnight job. It takes months to actually do that. So therefore, the earlier you start, better it is. So that is ignorance risk. Now, ignorance risk can be to some extent mitigated by conducting awareness programs. And now I'm not talking of awareness program for the desktop person. I'm talking of awareness program for the board directors. If the directors don't understand the risk, they will not provide either the funds or the freedom to the CISO or the DPO to go ahead. In fact, they will not appoint a DPO when the DPO is required to be appointed. So the ignorance risk should be handled at the top management level, including the board. And then, of course, it comes down to various levels in the form of various trainings and awareness programs. Second is harm creation. That is not preventing a privacy harm to an individual by a specific omission, which is what we are trying to identify as a risk assessment. Then security failure risk. We have made the risk assessment. We have put in place some security measures, but sometimes security fails. So we are not able to prevent the CIA breach of the personal information. That is something which has to be taken charge of by the incident management system. The current incident management systems, which most of us run, are geared to meeting the technical failures of the system or the process. But what we now have to do is to ensure that our identification of incident includes a situation which refers to a legal requirement which is not fulfilled. For example, having consent before collecting the personal information is a privacy requirement. Now, the incident management system, does it recognize a situation where a set of personal data comes and lands in the email of one of our employees? Now, this employee should realize that I have received some information, I have not taken the consent or how to use it. Now, should it be considered as an incident? If so, where should I report? Now, this is not captured by your SEM system or something like that, because it has come through the email and unstructured dropping of information. So that is where the incident management system from privacy angle could be slightly different from the currently known incident management system. The fourth kind of thing is the non-compliance risk, which is not fulfilling the obligations set in law, which is to be countered by compliance by design. So these are the major risks which we are talking of. The most important risk, as I told you, is the ignorance risk. Ignorance can come from ignorance of law. It can also come from the ignorance on whether something is applicable to my company. Now, is the law is applicable to me? What is the scope of its application? Am I processing the information that is covered by the relevant law? Who are the data subjects who interact with us? What information of the data subjects do we handle knowingly or unknowingly? What is our role in compliance? Whether I'm a data fiduciary or a data processor. These are the things which could be in the domain of ignorance, which the gap assessment should capture. I feel this is relevant both for the organization level compliance as well as DPIA at a process level. Now, harm creation risk similarly raises a few questions like, am I creating any privacy related harm to the data subjects in the process which I am looking at? Who are the individuals whose data I am processing? What kind of data is processed? What happens in the data transformation during the process? What is the output of the data? Who is the recipient of the output? What is the purpose of collection and whether it matches the purpose of processing? What are the storage parameters? Does it match with the purpose, whether I'm keeping the consent for a single purpose usage, but I'm keeping it for years together? Those are the things which creates a harm creation risk. And of course, the normal things like unauthorized access, modification, deletion. These are the things which we have to look at. And each of these harms, we may have to assign a significance value, okay, so that we know whether the risk is significant or less significant. So this is harm creation risk. Security failure risk is about reasonable security practice. And in the context of DPIA, now if you ask me what is the security, now here also within the process, data comes in, data goes out, data is being processed. There is a need for preserving the confidentiality, integrity, and availability of information. It includes accountability and non-repudiation, and it includes security against privacy harm. And the controls of security in privacy scenario, as I told earlier, is applied on personal information, which is a smaller set compared to the IS domain, but it is applied on a wider canvas, and security failure risk covers this. Non-compliance risk is the broader one. Am I complying with the overall data protection law? And this could be spread across the different articles or sections. Sometimes they are in the associated documents, like in GDPR recitals. In India, we are talking of the rules, notifications, and I have said due diligence is a much more complex situation. Case laws are an important aspect. Legislative intention is an important thing. EDPB guidelines in GDPR. These are all things which are to be seen in addition to the particular law, a particular section. So either 99 articles of GDPR or 30 sections of this DPDPB, they're the main thing, but there are several other things which you need to look at. That is where a broader understanding of the law is required. India at present does not have much of case laws, whereas GDPR, we already have hundreds of penalties which have been given, and all that becomes part of the understanding which a company should have in terms of the DPIA. I think I will try to take the break now, Manish, and perhaps
yes, sir. Thank you.
we'll then go ahead of the law separately. Okay.
May I request Mr. Vadraj to come over? We have something to announce from the BSPIN.
Yeah, sure. Can you guys hear me, Nagendra sir?
Yes, please go ahead.
I will stop the share and then you can
Please.
share it, I think.
Okay, let me go ahead and share my screen.
Mr. Sandeep Rao, can you go on mute, please? Thank you.
So let me know if you can see my screen.
Yes, we can.
Okay. Okay. Good morning, everyone, and good morning, Naavi sir, and Nagendra, and everybody on the call. So my name is Vadiraj Mangoli, part of executive committee of BSPIN, and I take take care of the membership part of BSPIN or something. So I'm going to take a few minutes just to talk about the membership benefits and then what BSPIN is into and all that stuff. Okay, so if you're able to see my screen, I'm just moving ahead and giving you some introduction about BSPIN. Before we get on to BSPIN, let's talk about SPIN. Okay, SPIN is a software process improvement network. That was an organization for typically quality professionals to begin with, which started with the Software Engineering Institute long time back, that is associated with Carnegie Mellon University in Pittsburgh, USA, in Pennsylvania, USA. So they started off these SPIN as groups wherein all the professionals will get together, share best practices, and so on and so forth. So when they started, there were almost about 100 plus spins, and some of the popular spins that I have listed over here, includes Bangalore spin also. That is the one that we are part of. So we also had Chicago, Milwaukee, Ottawa, Tehran, and in India, Hyderabad, Pune, Kolkata, and Delhi, and all that stuff. So this is about a little bit of background about the spin, because this spin is not only associated with Bangalore city, but it is kind of worldwide. So so looking into the next one, so let's talk about or look at what BSPIN is all about. So our BSPIN was founded or started being active in 1992 with a very well dedicated set of quality professionals. Okay, so if you look at 1992, so we have just completed about 30 years last year. Okay, so it's a long one with a lot of achievements and a lot of dedicated people and so on and so forth. I myself have been associated with BSPIN for the last about 10 years or something, so I've been part of that. Okay, and if you look at that, our mission is to ensure that the collaboration between people, companies, and organizations, is enabled, and we have a lot of learning, from the practitioners, who are part of BSPIN, whether they are members, whether they are ECs, and set of SMEs and industry leaders like Naavi sir in this case, will come in and share their experiences and other things, on various topics or something. So that is something that we enable so that people are all benefited out of that. Okay, so and just to let you know, BSPIN is a forum which is not for profit organization, though but it is a registered society with the registrar of Karnataka or something. And you can also look at BSPIN. We have our own website called bspin.org, and I mean, this is one of the largest operational spins as of now, because what we had heard in the last few years is the other spins have been either going down or be not so active, but it's been great with everybody's contribution here, so that we have made BSPIN, quite active even now. Can people go on mute, if they don't have any questions? Thank you. Okay, so again, I did talk about the vision and mission of BSPIN.
Mr. Jayanandan, can I go on mute, please? Mr. Jayanandan, iPhone. Thank you. Go ahead,
Thank
sir.
you. Thank you. Sorry. So we did talk about the vision and mission of BSPIN. I just want to kind of reiterate that. So our mission is to ensure that an environment and an opportunity is created for all the practitioners within this industry, and to develop knowledge, skills, and share best practices or something. Okay, so I mean it creates a great networking opportunity. It's unfortunate that for the last about 2 or 3 years we have not been able to meet physically, in a way, thanks to COVID, and we have been having a lot of online sessions or something. But otherwise, at least we used to meet once in a quarter, and we used to have great networking opportunities, and then but we're still looking at having something in a physical meetups in the coming months or something. So we also partner with industries. I have just a slide about it, and we also bring in again specific practitioners within several industries with several domains, and they all will go ahead and talk to us about their own areas and their domain expertise or something. And this is definitely a collaboration platform where professionals can. There is no restriction. Anybody with a good knowledge of a particular domain can come and share this best practice. Again, what do we do? So we have we hold a lot of workshops and conferences, wherein bring in a lot of people from industry. Okay, so we also have discussion forums. Okay, industry connects, wherein a lot of industries will come and talk to us about their domains. Again, I did talk about networking tutorials, and then we also hold quite a few competitions and things like hackathon and so on and so forth, which we should be expecting in the coming months. Okay, how do we get associated with BSPIN? So we have a lot of corporate members. If you look at that, there are quite a few logos that you can see, who are all industry leaders in their respective areas. Again, we have been associated with all of them, and we've been kind of being supported by each and every corporate member. Okay, what do we get being a BSPIN member, whether it is a corporate member or an individual member? So we will have access to exclusive BSPIN and its related activities or something. So we have a website. We have quite a bit of information that is available. It could be like you know uh, the the PPTs or the white papers or the industry knowledge sections and so on and so forth. And as we said, we have a lot of BSPIN events that are being organized, whether it is online, offline, paid or free, or so on and so forth. And everyone who becomes a BSPIN member, as well as people who are associated with BSPIN, will be invited in for such sessions, and to be part of that. And for the paid sessions, the BSPIN members who are paid members will definitely get a concession and complimentary access to that. Okay, and I did talk about guaranteed discount on others, and BSPIN also is associated with other organizations, similar organizations, like ESQ, FDPPI, and so on and so forth. Whenever they hold their own sessions, then the BSPIN paid members are also given discounts and concessions and so on and so forth. And BSPIN used to be known for some of the best industry benchmarking reports. You can also contribute being part of that, and you should be able to get reports on that. Okay, again, we did talk about networking opportunities here. I think we have got about what 60, 70 people. Everybody's a SME in their own world or something. So we will have a great networking opportunities. And we also hold volunteers, or we invite volunteers to come into BSPIN, be part of. There are several groups within BSPIN. You can be part of volunteer and contribute yourself into the area where you're interested in. So you can actually reach out to one of us, if you want to become a volunteer. Okay, so there are some details about the BSPIN membership here. Individual members as well as corporate or organizational or institutional members. I think the details are given over here. You can become a 1-year member as well as 10-year member, paying that amount. Okay, and corporate and institutional members, wherein 5 people from that respective corporate will be able to get the benefits of being a BSPIN member or something. So, for example, 1 year it costs about 10,000 rupees, and then 5 people from that organizations will get benefit of a BSPIN member or something. Okay, I mean, there are some details about how do we pay and so on and so forth. You can write to me on membership at BSPIN, or I should be able to provide you more details on that, or you can also write to info@bspin.org, for generic queries or generic details, or if you want to become a volunteer or something. And if there are any queries on membership, you can reach out to me at membership@bspin.org. If are there any questions, you can probably take a couple of questions if there are. Otherwise, we can move on.
Any questions?
Okay, thank you very
All right.
much. I did share my email ID, membership at bspin.org or info@bspin.org. You can reach out, and if you have more details. And thank you very much, Nagendra sir, for giving me 5 minutes. I hope Naavi sir had a little break to take it to the next level. Thank you very much, sir.
Thank you very
I'm
much.
stopping sharing right now. Thank you.
Yeah, thank you. So I would request the members to come on board of BSPIN, share, collaborate, run your experience and challenges, share the solutions. We'll grow together. Thank you very much, Vadi.
Thank you, Nagendra.
Okay, shall we continue?
Yes, sir. Go ahead, please. Thank you
Yeah.
so much.
So friends, if you have any questions till what we discussed now, you are welcome. Otherwise, we will get into the nitty-gritties of DPB. At every point, you please try to relate it to what we have discussed as risks conducting DPIA, and see how these legal aspects can be related to the identification of risks. Now,
sir, now is one question quickly.
Yeah,
do you think we will open for the questions by 11:30?
Yeah.
Okay. Thank you.
Yeah. So now we quickly go through this act. This has got discussions on preliminary aspects of applicability, then obligations, rights, then some special provisions like cross-border transfer, then the compliance framework. Then I will also perhaps look at some of the things regarding how it relates to the ITA 2000. Now, this act is going to be regulated through an organization called Data Protection Board, which will have a CEO appointed by the government. Addition to this, which has got the powers to inspect, inquire, and impose penalties up to 500 crores, we must remember that there are other law enforcement agencies, certain adjudicator under ITA 2000 and courts, which also, in a way, form part of the regulatory structure. Penalties, I told you that maximum is 500 crores, but there could be penalties, let's say, for failure of the data processor or the data fiduciary to take reasonable security practice. Penalty could be 250 crores. On data breach notification, there could be penalty up to 200 crores if it is not notified. And then for handling the children's data, if there is any omission, it can also be 200 crores. Then not appointing a DPO, not conducting a DPIA, not organizing a data audit, there could be a penalty of up to 150 crores. Then there is a non-compliance provision up to 50 crores for anything which is not indicated here. There is one very peculiar penalty here, which is 10,000. This is actually the penalty not to the company, but to a data principal if certain duties expected out of him is not fulfilled. For example, this act expects a data principal not to make a false claim on a organization and in a way cause an unnecessary damage to the organization. So such things, there could be a penalty imposed on the data principal. for some making some innocuous complaint and just to ensure that the company is harassed. Okay, so that is the penalty structure: 200, 250 crores, 150 crores, or 50 crores, and maximum up to 500 crores. So when we are conducting a DPIA in this scenario, we are looking at a subject process, but the subject process actually will have an input from the previous set of processes, and it will give an output which goes into the next process. So when we are describing the subject process, we need to ensure that our description includes the previous processes, which leads to the generation of what would be the input for this, and also the how this process relates to the subsequent process. That is why there may be a requirement of the process mapping, record of processing at the organizational level, which we normally do as a part of our privacy by design policy, or creating a compliance by design manual. So that record of processing should be there, in which we have to highlight that this is the process on which DPIA is being done. So that is the kind of description which we need to have. And this description may have to say that something like in a simple web form collection, it may say collection of data from the web form at such and such a URL or whatever is that, and storing them in a classified manner. The classification could be personal, non-personal, because these are all the things which may happen during the process when the data collected from the form is then put into a database. In the database, you are anyway creating various columns, and those columns will be having this classification of personal, non-personal, and so on. So this is the description you have to do. Now, applicability as far as the law is concerned, this law applies to digital personal data processed within the territory of India, which is online. And sometimes if you collect the data offline and then process it, that also comes under this. But if data is processed outside India, if that is in connection with the profiling activity in India, that also comes under this. This is the standard aspect which is used even in the GDPR, extraterritorial jurisdiction. But this law is not applicable to non-automated processing, offline processing, then domestic purpose processing. And one more thing which says is that any record which has been in existence for at least 100 years, this law is not applicable. Now, the significance of this will only be found for a period of time. But otherwise, most of the IT companies need not bother much about that. But if you are a company which is archiving data of historical nature, if you are trying to have personal data of, say, historical character, then obviously this law may give you an exemption if the document is 100 years old. Okay, but of course, that may be only of an academic interest. Now, the risk associated with this applicability clause, as far as we are concerned, is the risk of wrong classification of data or the entity. So what is protected data? What is the protected, who is a protected data subject? What is the role of the entity? These have to be properly characterized. Otherwise, there could be a risk. So data classification, first of all, you have to have personal and non-personal data classification. If you classify personal data as non-personal, it is going to result in a risk. Then employee and non-employee, that classification is important because the law may apply differently. Minor and adult, it is required. Identifiable information or encrypted or pseudonymized information. So this kind of data classification, if there is an error, that could be one of the risks. Second kind of risk is jurisdiction application. The personal data is from India, from outside India. That depends, that determines one of the risks as far as this applicability clause is concerned. Along with this, there are certain exemptions this is again common to all regulations, including GDPR. Some data may not come under this law. Some data subjects may be exempted. Some data subjects may require special attention, like the minor. Then cross-border restrictions could be there, or it may not be there. Some processing may not require consent. Some incidents may not be considered as data breach. Some data breaches need not be reported. These are all things which we need to look at as exemptions and derogations as part of understanding the applicability and classification to a risk assessment. If we make any mistake here, then that itself becomes a risk. That is what I call as a risk in interpreting the applicability clause. Now, automated processing, we say the provisions of this act shall not apply to non-automated processing, which is the manual processing. Automated is defined as any digital process capable of being operated automatically in response to instructions given or otherwise for the purpose of processing data. So even if you are using an artificial intelligence and you are not giving specific instructions every time, it is still coming under this definition. So whether you use a software of an ordinary variety or the self-learning AI, both of them come under this. And you have to look at this automated processing along with Section 11 of Information Technology Act, which attributes the activity of an automated process to the owner of that process. So therefore, the legal consequences of an automated process lies with the owner of that process. Okay. Now, one of the risks which we need to look at is how the law handles the deceased data principles. Now, this law says that there is something called nomination. Now, which means that there is an attempt to address at least one aspect of a deceased data principle. Normally, a deceased data principle is not having a privacy right. So if you are talking of a GDPR, it may not be applicable to deceased. The privacy rights are not applicable to the deceased persons. But information security normally is irrespective of the person's whether he's alive or not. But the problem in implementation is, how do we know when a data principle has expired? Somebody writes to you and says that my father has expired, I would like to have access to the information. Do you agree and then give it? Because today there can be so many kinds of phishing. There have been instances where death certificates have been faked, in some cases in property transactions. So what if you simply receive an information that my relative or somebody has expired, I would like to access his Dropbox or whatever is the data store. Then how do we know that he has expired? What is the kind of verification which we have to do? These are part of the DPIA process. If you are processing data of a particular person, either in a single process or in the corporation, you should also have an answer to these questions. How do we identify who are the legal heirs? And how do we transfer the ownership? Is data a transferable asset? Is it an asset at all? Whether it comes under the Movable Property Act or Movable Property Contract or something like that is a question which you have to raise, because wills are not recognized in electronic form in India. So if there is no will, then how do you have a nomination? Nomination then there has to be done by a physical document. So even though you are doing a business online, if you want to be compliant with the nomination facility as provided under this act, I have to have a system whereby somebody is given an option to send a written letter with physical signature and say that I am nominating my account to so and so in case of my death. That written document is recognized in law, but an email of a similar nature is not recognized in law. Now, what happens to unclaimed personal data? See, when we talk of personal data, many of the personal data elements are assets of monetary value, because it may have, let us say, an NFT code or a Bitcoin wallet ID. They are having a lot of value. So If it remains unclaimed, what do we do? So these are one of the gray areas which arise out of this DP-DPB. Now, as far as the role definition is concerned, it is easy to look at data fiduciary and data processor, because that is similar to data controller and processor. Data fiduciary is one who determines the means and purpose. Now, some of them may be called significant data fiduciary. The government will look at the volume, look at the sensitivity, and any other reason, including whether the activity of the significant data fiduciary has an impact on the electoral democracy of the country, something, or national security. Now, those are the criteria under which a significant data fiduciary may be identified. There is also something called a consent manager. This is a special category of data fiduciary. So the moment the act comes into existence, you have to check whether you are a significant data fiduciary or ordinary data fiduciary, whether you are a data processor or a data fiduciary, and whether you would like to become a consent manager. Consent manager is something which you might not have thought of. It is a separate category of data fiduciary, and it has got its own, it's a business proposition. And a consent manager acts as a trustee of the personal data of the data subjects or the data principals. Consent manager is not an agent of the data fiduciary. So if I'm a company, I cannot say that I will have one of my agents, the subsidiaries, acting as a consent manager. It will take care of only the consents. That is not the concept. Consent manager is a representative of the data principal. So that is something which you have to look at. Sometimes you may also have to check whether you are an intermediary under Information Technology Act. Now, one of the things which you have to remember is the role may actually differ from process to process, from data set to data set. There is nothing like a company is a data fiduciary, it is a data fiduciary in all processes. No, it may be a data fiduciary in one process, it is a data processor in another process. It may even vary from one set of data to another set. So role definition is something which needs to be looked at from the point of view of the particular process. In DPIA, there can be perhaps one single role for the organization. If there is a mix of data, and in some data it is a data fiduciary, in some data it is a data processor, you may have to conduct separate DPIAs, DPIA 1 and DPIA 2, because you need to have that differentiation. Now, I already said the significant data fiduciary is determined on the basis of volume, risk to electoral democracy, security of state. That is how it is defined. Consent manager, and then in the case of ITA 2000 intermediary, subclassification of social media intermediary and significant social media intermediary based on the number of members, that is a class. So all this will have to be taken in terms of roles. Now, if you look at the obligations set by the Act, one is, of course, the lawful basis. Second is issue of notice, consent, then special obligations to minor, general obligations, and special obligations. There are special aspects such as deemed consent and exemptions. I will try to quickly go through these requirements so that you will get an idea. We already said that there are exemptions and legitimate interest. Normally, exemptions are available for certain obligations like notice and consent, but normally security is not exempted. So even where notice exemption, consent exemption is there, there is no exemption from security. Exemptions could be there on the rights of the data principal who can exercise, and in some respects on restrictions on cross-border. The circumstances under which that exemptions could be given is when there is a legal right for the processor, that for his own legal right, he has to process. That is one situation where he can claim exemptions. Then, of course, courts and tribunals are exempt. Then, if the data is being processed by the law enforcement for prevention, detection of any offense, there is an exemption. Then, personal data of data principals not within the territory, which is foreigners' data. if it is being processed pursuant to any contract entered into with a data controller, that is exempt from the Indian data protection law. Even in the earlier act, there was on section 37. That is what this particular thing is talking of. That is, if you are processing data of an EU organization under a contract on behalf of a EU data controller, you can say that that is exempt from Indian DPDPB. But this will apply only if you can segregate the data and put it aside. And if there is any query from the Data Protection Board in India, you are able to tell them that this is a different data center, it is processing is different, there is no mix-up, then that exemption can be claimed, which means that there has to be proper documentation for that. Then apart from that, government retains its right to give some exemptions. I don't want to go through this. This is what many of the privacy activists will be perhaps discussing. We as corporate entities are not concerned much with this, which is actually a controversy which people like Prashant Bhushan has to worry about. Now, if you leave that, the risks are arising out of non-compliance of what is called general obligations are roughly like this. Now, according to the general obligations, every organization, data fiduciary, is responsible for the compliance of the entire act. So anything which is not complied, that becomes a risk. Then reasonable efforts to maintain accuracy and completeness of data is a general obligation. Not doing that is a risk. Implementing security safeguards is an obligation. Notification of data breach is an obligation. Remove when the data, when purpose for which it was collected is over, is an obligation. Therefore, not doing it is a risk. Publishing business contact information of the DPO or a compliance officer is an obligation. Not doing so will be a risk. DPO is required only for significant data fiduciaries. In the other cases, somebody similar to that should be there. Now, having a grievance redressal mechanism is an obligation. Not having it is a risk. Have a proper contract for transfer of data to a data processor is an obligation. Not having a proper contract is a risk. So that is how we are interpreting the general obligations. Now, when we talk of lawful basis, in GDPR, we talk of several things as lawful basis. Here, basically, we say that something to be called as lawful, it should not have been declared as unlawful. For example, if cryptocurrency is declared unlawful, any processing of cryptocurrency will be unlawful. So within that premise of lawfulness, there has to be a proper notice and a proper consent. They become part of the lawful basis. So there's only informed consent as a major say way of processing. Other than that, of course, legitimate interest I already said. So therefore, that is a requirement which you can process data if it comes under legitimate process, even if there is no notice or consent. Similarly, some emergency situations like the disaster kind of a thing, natural disaster and other things come under the exemptions. So these are the lawful basis as far as the processing is concerned. Within this, there is also an element called deemed consent. What is special about notice is that the notice has to be expressed in all the scheduled official languages in addition to English. So 22 official languages are there. So notice, which should be in clear, easily understandable form, should be expressed in all these languages. We need to give notice in the case of legacy transactions, even to the data principals who have already given us the data. So this is one of the important compliance aspects which we need to do. Even if you are having certain processes now, the moment law comes into existence, all these earlier consents become infructuous. You need to take fresh consent. Therefore, DPIA is required for all your existing processes once the law comes into existence. And the notice should have, of course, the right to withdraw, right to grievance redressal. So these are part of that. Now, as far as the consent is concerned, obtaining the consent in a lawful manner, like a contract, means that it has to be properly authenticated. There, on the electronic document side, you know that Indian law only recognizes a digital signature or e-sign as the proper way of authentication. Other than that, you have to have a Section 65B certified record. So this is another big risk which companies need to learn how to mitigate. If you simply take a click wrap contract, it is not going to be a good consent. It is a deemed consent, but not equivalent to a full consent. Request for consent should also contain the details of the DPO, his contact details, and the grievance redressal process. So these are some of the things which you must remember. Consent manager can be appointed by the data principal, and this person can not only give consent, he can manage the consent, he can withdraw the consent, he can review it from time to time. So a lot of powers are given to the consent manager. He requires to register himself with the data protection board separately as a special data fiduciary, and there will be separate sets of rules and regulations for that. But bonus of proving that a consent was obtained for processing is on the data fiduciary. So he has to keep proper records. So if you don't have a record of consent, and if you don't have a tag attaching the consent to the particular data set, that will be a risk. As far as deemed consent is concerned, to some extent, this can go with the exemptions. There are certain situations where the data principal is deemed to have given a consent, and it includes certain very important activities such as the employment scenario. Then, of course, medical treatment, and where there's a threat to life is there. What is important for us is it includes the information security, things like including the prevention of corporate espionage, maintenance of confidentiality or trade secrets, intellectual property, regarding recruitment, termination of employment. So there are a number of practically useful situations in which a deemed consent can be presumed. So you must be very clear of where to use this deemed consent and ensure that it is properly brought into the policy documents, particularly with the employees, because employees are the biggest risk for, say, some action against the organization using the data protection law, because employees are aware of all the inside information about whether you are compliant or not. They know better than anybody else. And if they want to take some kind of a revenge on the company after they leave, instead of going to that glass door or something like that, tomorrow they can send an anonymous complaint to the data protection board. So handling employee risk is very important. But in that, there is a provision of deemed consent. Where to use deemed consent, where to use specific consent is a decision which the DPO has to take. Another area where deemed consent is recognized is when data is collected and processed in public interest, which includes prevention, detection of fraud, mergers, information security, credit scoring, recovery of debt, and processing of publicly available personal data. So the deemed consent provision is very industry friendly, but you need to have appropriate documentation to ensure that you remain compliant. There can be, of course, any other fair and reasonable purpose which you can justify. But remember that there is something called deemed consent. So consent is required, mandatory, deemed consent is available. Now, as far as the special obligations are concerned, the risk is that if you are designated as a significant data fiduciary, then you need to appoint a data protection officer, appoint an independent data auditor to evaluate compliance, then conduct DPIA as well as the periodical audit. Now, the DPO has to represent the significant data fiduciary. He should be based in India, and he should be an individual responsible to the board, and he should be a point of contact for grievance redressal. If these are not built into the definition of the role of a DPO, you can say that is a risk arising out of not properly designating a DPO. Then, as far as the rights is concerned, this law recognizes right to information, right to correction and erasure. It does not speak of right of portability. It does not speak of right to forget. Some people read right to forget within the right to erasure. That is a matter of debate. Then right to grievance redressal is important. Right of nomination is there. And we have certain duties to the data principle, that he will not register a false complaint, he will not suppress the identity information, shall provide verifiable identity when it is required. These are some of the duties. But as far as the rights are concerned, it is slightly less than what is there in GDPR. And based on that, risks should be very examined. Then, as far as the minors is concerned, basically the risk arises if you are not able to have a verifiable parental consent, and the data has to be processed without causing harm. No behavioral monitoring is required. There could be some exceptions to certain category of minors data processing, which is like counseling, not for BYJU'S and others. So these are the cases where minors, which is people of less than 18 years of age, their data is handled, and any omission could result in a serious consequence as far as the law is concerned. Then as far as cross-border restrictions are concerned, the law has been made very simple. The government says that they will notify adequacy countries, which essentially means they may enter into bilateral agreements with various countries. There is also a thought which is circulated by the ministry saying that they may recognize special data processing zones where, like a diplomatic mission of a foreign country, data of the residents of that country can be processed without the effect on the Indian law. So those are the things which we have to see how it comes. Some people are saying that there will be a negative list only and the rest of it will be left for transfer. This is an emerging aspect. We are not clear what will be the final view of the government. The most probable thing is they may come up with a white list of countries to which data can be transferred freely, subject to a contractual commitment of security. That will still remain. So whether it's a standard contractual clause or a BCR kind of a document, that may still be required when you transfer data to any other country. And obviously that will also be incorporated in the consent notice. Now, while on this, we need to also look at risks which may arise due to non-compliance of ITA 2000. When this act comes, then section 43 capital A of ITA 2000 will be deleted, but there will be other things such as intermediary guidelines under section 79, section 4366 could be there, 67C could be there, 72 capital A is there, then section 69, 69A, these are all sections which give powers to various government organizations to seek information. Then impersonation is covered under 66C and D, which is related to the data protection. Then there's something called 66E, which is there, and terrorism 66F is there. So these are all sections which may have relation to data protection, but they will not be deleted. Only a section which will be deleted is 43 capital A, which means that most of these sections could have impact in some case or the other. So keep one eye on Information Technology Act, which itself may be completely revamped, and a Digital India Act may surface that will have some effect on data protection laws also. particularly the use of AI and other things will be covered in this new Digital India Act. Metaverse will be covered here. So keep an eye on ITA 2000. Now, if this is what is required, the question is there any compliance framework which you can adopt for compliance? Now, it is here that we are trying to look at the PDPSI, Personal Data Protection Standard of India, the latest version 2023, which will incorporate this DPDPB. It will be addressing all the requirements of DPDPB. So if there is going to be a framework which is directly related to compliance, it will be PDPSI. It will not be 27701 ISO because this is more for GDPR. IS 1742A, it is also not fully focused on the Indian law. They may sooner or later will change their focus. They may come up with an Indian version. Then they will follow what PDPSI is today. Apart from PDPSI having some of the advanced concepts which are unlikely to be incorporated in any revised version of ISO also. But this will be flexible enough to address the compliance of GDPR and other laws, including the special data zones. So that way it can simultaneously, it can be a unified framework for both Indian law as well as any applicable foreign laws. Additionally, it will incorporate a maturity measurement in the form of data protection, a data trust score. And as of now, we have already incorporated some methodology which will make it amenable for self-assessment by a company. Then if the company wants some mentor-assisted assessment, that also is possible, and also a certifiable assessment. All of you need to take a separate look at this PDPSI. You may be surprised to see it will contain things which have been missed by many other frameworks. So we are using it as part of FDPPA recommendations. It consists of 50 model implementation specifications. Responsibility is spread across 5 responsibility centers. As I told you, IT, law, HR, DPO, and management. Evaluation of the risk will lead to the calculation of DTS, and the same framework can be used for DPIA risk assessment also, with some small modifications, or certain model specific implementation specifications can be dropped because DPIA is for one single process, whereas PDPSI was actually conceived for the compliance of the entire organization. Now, just to give you a bird's eye view of what these 50 model implementation specifications have, as far as IT responsibilities are concerned, it contains all the usual aspects which you come across, like record of processing, tagging, having an inventory, classification, then legacy data processing, unstructured data processing, access control, security in transmission, storage, and processing, malware control, patching, data deletion, DRP, incident management, data leak prevention, and including physical security. So all the responsibilities which are normally there in the current ISO 27001 are included as responsibilities of the IT department. Legal department will have some responsibilities on contract control and grievance redressal system. HR will have some employee privacy management, which we consider should be handled separately. Augmented HR policy, data asset responsibility, work from home. These are responsibilities of the HR. Then DPO will have 9 specific responsibilities, including development of all policies, profiling policy, notice, data breach identification, cross-border, impact assessment, and documentation. So all these are responsibilities of the DPO. Apart from this, the top management itself is considered to be responsible for at least 15 model specifications, which includes designation of the DPO, having an augmented whistleblower system, which incorporates your bug bounty program into the whistleblower system, data valuation, and pseudonymization policies, distributed responsibilities. So this PDPSI is far ahead of the current concept of, say, what the ISO standards speak of. People may say that, okay, FDPPI is not ISO, fine, but FDPPI can work better than somebody else. So the framework PDPSI can be better than the ISO 27701. It is only for you to evaluate this and come to a conclusion whether what I am saying will definitely happen. Now, I will end my main discussion here, and now it is time for questions, and we'll see how many questions come up. We will also perhaps reflect on this case. So if you have any questions, either you put it on the chat box or perhaps give.
Yeah, thank you, sir.
Yeah.
So there is one question by Saravanan. If a company is compliant to GDPR or 27701, is there any additional control recommended as a part of DPD-PP 2022?
See, as I was explaining, GDPR requirements can be different from DPDPB requirement. Now, tell me, where is nomination aspect in GDPR? It is not there. So whether you are having 27701 or any other framework, obviously it will not cover the nomination requirement. Now, as I told you, the minor recognition is different. Now, grievance redressal is a mandatory provision in India. On the other hand, GDPR recognizes the right to portability. We don't recognize right to portability. So compliance to GDPR is not considered equivalent to compliant to DPDPB. One. Second, GDPR is applied for data which is relevant for GDPR, which is personal data of persons residing in EU region or citizens of EU region. Now, a citizen of India is not covered under the EU. You may say a citizen of India now in France or Italy, his personal data processing may be covered. But an Indian citizen whose data is being processed in India is not covered by GDPR. So being GDPR compliant is not equivalent to being compliant with DPDPB. And if you try to extend that and say, since I am already GDPR compliant, I don't have to do any compliance for DPDPB, there will be shortfall, so that you will not be able to justify a query under DPDPB. At best, you may say, I've got pseudonymization, I've got encryption. These are common aspects of most of the data protection which you may have. But there are several things which are not there. And if you do not properly map the two and run DPDPB separately, you will have a problem. In fact, you will hit the block right at the data classification. I am going to segregate the GDPR stake data from the DPDPB stake data, and then apply DPDPB stake data, the DPDPB compliance requirements on DPDPB compliance data, which is data which is collected and processed within India or collected and processed outside India, but involving the profiling of Indian citizens. That data is what comes under DPDPB. But if I have got a data of a EU resident or a EU citizen, which is being processed either within the EU region or it involves profiling of a EU citizen, even though processed outside, that comes under GDPR. So the two cannot be mixed up. You need to separate the data. That is part of the technical process which you have to do. So when you do a DPIA also, you have to see what is the input data, where is it coming from. So in this Divya Drishti case, if 70% data is 75% or 70% is coming from, say, a from India, that data has to be in a data store to which DPDPB is applicable. So if a person is 18 years of age in this database, that is the distinction between minor and a major. Whereas in the EU database, which may be 10 or 15% or whatever is that person actually, you may have a 16 year as a limit for minor, in some cases, maybe even 13 years. With the employees, this thing is totally different. GDPR recognizes the employees' rights much more strongly than the Indian right. So depending upon the country of origin of the data, instead of course, we have to call it as the jurisdiction of law rather than the country of origin, because a person, the origin of the data can be from, say, EU, but it may be subject to Indian law. There could be some special situations like that, but you need to identify right in the web collection form, which is the jurisdiction which has to be applied, and appropriately classify either the data as related to GDPR, data which related to DPDPB. There is no conflict, but the two are different. The law which you apply for apples, you cannot apply for mangoes. Okay, mangoes you put under say grass and other things. You don't put apple under grass, no, like that. So the protection is different. Am I making my point clear, sir, Mr. Saravanan?
Yes, thank you, sir.
Yeah. Aravind.
Next question, Arvinder, can you make for your first question clearer? You are expecting gap analysis checklist between what? So can you
Gap
report your
analysis
question?
between what is required under DPDPB as per an assessment of a consultant and your current status. Okay, so the checklist which I will have will talk about what is required for DPDPB, some of which I have tried to explain now. In fact, we have segregated it into nearly around 100 odd questions. These 50 implementation specifications are actually converted into certain questions, which is present in the online version of DTS calculation. In fact, the whole questionnaire actually contains more questions, but crux of this is captured in about 100 and 150 questions. So those are, that forms the checklist. Now, there is an online DTS. Of course, I am going to slightly refine that as soon as the government releases the final version. Until that time, you can say that we are still working on this current draft, but we are ready with the DPDPB 2022 version, which has been released for public debate. On that basis, we have a checklist which can be used for making a gap analysis. Okay. Should a
DPO register with DPD in India?
As of now, there is no such information because we are now having only the act. Now there will be rules and notifications. For example, if you look at the intermediary guidelines, which we are discussing in depth for the last few days, intermediary guidelines is a 31-page document. The section 79 is a 2-paragraph section. So when you expand it, there will be a lot more details which will be coming. As of now, they say DPO should be residing in India. That is a requirement. DPO should be reporting to the board is a requirement. Then the functions of DPO are there. So accordingly, credentials will have to be built around that. So about the registration, it is not there. For data auditors, there may be a registration because the government, the DPB may accredit data auditors. See, data audit is different from statutory financial audit. So a KPMG auditor or a chartered accountant is not necessarily a person who is also considered as a data auditor. So for data auditors, I expect there will be a registration system. I do not know whether for DPO, the government will use that. Earlier, they had not mentioned that. So as of now, you can say there will be no such registration.
Is there a DPIA checklist?
There is a checklist which we are using. Say when I conduct an audit or my firm conducts an audit, as I told you, it is derived from the DTS computation checklist, which part of it we have made available for self-assessment on the online portion. So from there, a DPI checklist has been developed. Yes. But
Yeah, that's what I was actually looking at. Is there a self-assessment before going in for an external assessment to make sure that we are compliant? That is what I was looking for, sir.
Subraido? Is it Subraido? I didn't get the exact.
No, it was Arvindan. So the person who had asked these questions. So from that perspective of gap analysis and the checklist, I was only looking at the self-assessment, which could be done as a first level before we go ahead and make a final assessment.
We have made that kind of a thing on a self-assessment basis, but when a self-assessment, the question will be there, you may not understand what is the question. Now, of course, we have gone through 2 hours of discussion, so some clarity will be there. If you simply go to the questions, there may be some difficulty, but if necessary, there can be a mentor-assisted completion, and it can be converted into a DTS assessment. That is, in terms of DTS is a 1 to 100 kind of a score, credit score. So you can use that. Otherwise, you will have to check with one of our accredited auditors for an assessment. Yeah.
Sure. Thank you.
Yeah.
Thank you, Mr. Arvinder. What could be the checkpoints to be considered for privacy assessment for contract signing? Question from Neha.
Contract signing, first of all, you should define the roles of A and B entering into a contract. Who is a data fiduciary? Who is a data processor? Sometimes a contract has got multiple obligations. For example, I give you something and I receive something from you. That is first part. Second part, you give me something and I will give something else. So it may be a combination contract. One example I can give is, say, I am a software developer, a platform developer, let us say. I give my platform using license to you. So I am the seller, you are the receiver. It's a software licensing kind of a thing. Then you say that the data is being collected by the platform. You please manage the data in my AWS. So then you are giving me another contract saying that your data collected through the licensed software should be managed by me. Now, in the normal, say, DP contract, data contracts, both are combined into a single contract. But I distinguish the roles there. In one case, you are a software licensor. The other person is a software licensee. That contract is over. Now, the licensee says, now, as per the license, I am the owner of certain data. Forget that it was collected through your platform or something like that. I have data which is mine. You are not the owner of my data. Now that data, I ask you to do some kind of a management. Then it's a reverse contract. So that is a data processing contract. That kind of distinctions have to be done in the contract. Otherwise, the contract will have to have the identity of the parties. Minimum is the email and the rest of the contractual requirements, including the liabilities arising out of that. That is why in our PDPSI contract portion, we have said that contract control is an important implementation specification which needs to be taken into account. Because what is required there is every contract of an organization needs to have an identity of its own, a serial number. And it should identify who is the owner of the contract. There has to be a contract manager. Okay, he may be a process owner or he may be a business owner, but he should be responsible for that particular contract. And his email address should be there in that contract. That kind of a system is what we are expecting an organization to have. Okay.
One question from Raghu Norman. From your experience, please share pain points and implementation.
The biggest pain point is classification and creating a data inventory. Okay. I find it very difficult to pass through that stage because most of the companies do not have a proper classification system. Once you have a data segregated into various, say, data stores, then applying certain controls will become easy. So I think that is the biggest pain point. Then, of course, the people, unstructured data, what happens unstructured is, say, web form, collecting the information with a particular, say, notice becomes easy. Okay, because all the information which you collect, you can put it into that form. The problem there is about whether it should be GDPR form or whether it should be the Indian form. That is a small aspect. But unstructured data doesn't come through the system. It lands in the hands of an employee. That is where our concept of distributed responsibility, where every employee is considered a DPO as far as his area of operation is concerned. And when he finds some personal information, identifiable personal information in his hands, it is his responsibility to hand it over to the DPO or whoever is the custodian of data and delete immediately from his custody. That is one problem which we always have. And also the incident management system is a pain point in the sense that people don't understand the legal aspects of the incident, because a help center person does not understand the concepts like whether there's a lawful basis for some information, or suppose while talking the person, they may give out more information like the credit card number. How to deal with that situation, because it's also going to be recorded somewhere. So you might have told the customer that you don't give me any personal information, but he still gives that information and it goes into the record, and the record of the self center may not be properly secured. Everybody else may be looking at it. So the credit card data of one customer giving some part of his complaint gets recorded. So those are things which happen because that person who is collecting the information is a help center call center person who does not understand the legality of the information. So making every employee of an organization aware of the techno-legal responsibilities is perhaps another pain point. Like that, there are a couple of things which we can expand. Yeah.
Any other questions, guys?
Hi, I think I have posted a couple of questions. Hello, Vijay and Nagendra.
Hi, Vijay. Please go ahead. I don't see right now. Yeah. Please go
Okay,
ahead.
maybe my questions are too much of typing.
Oh, is it? Okay.
Yeah. So my first question was like, I'm just posting the questions which we face as a challenge in our organization. Basically, I'm the DPO in Happiest Minds, Bangalore.
Okay.
So one of the challenges that, we have got certified recently last year on ISO 27701. And the first challenge that I would like to ask you is, see, employees, managing the employees' PI, right? That is the highest data privacy risk that we see. But as per the standard or law, we need to take their consent to process their information, isn't it? But we cannot, at the same time, if you see, we cannot fulfill their data subject rights. Like if they say, for example, if one of the employees says that I don't want to, I want to opt out from processing my personal information or my sensitive data. So how do we balance this, like ensuring that we meet the, data subject rights at the same time we take the consent? So it's like contradicting for us.
Right.
We are having a tough time now, like what to do, defining is policy here itself is becoming a challenge. So I'm not able to fulfill all the rights. Right. So that's what I would like to hear your advice, like what can we do in this situation?
No, I recommend a separate employee privacy management, which as a policy. You cannot manage the privacy of an employee equivalent to a manner from the public. Even the employee who has not been onboarded, okay, he's also a public, because employees, they have privileges. Now, when you give privileges, there has to be certain duties cast on them. That is what Indian law does. So now you are allowing your employee to have the most critical corporate information. You are perhaps giving them privileged access in certain cases. They cannot expect the same privileges as an outside customer. Okay, right. GDPR does not make this distinction. And that is why you have got cases where an outgoing employee goes and files a case against your company. That is why I said this is going to be a big risk
Yes.
there.
Yes.
So
Yeah.
you need to have a separate contract with them. And even, of course, GDPR says that you cannot have a contract which overrides the privacy rights, etc.
Right.
Okay. But still, you have to make a explicit contractual arrangement with employees who have to say that I am aware of this, my rights, but in this particular situation, you see, for example, fraud prevention. Now, for fraud prevention, I would like to monitor my employees' activity. Now, you ask me, I will even try to understand the life habits of a person. If I'm paying him, say 5 lakhs as an annual salary, and he goes and buys an Audi car, that is an information which, as a fraud observer, I consider it as a very serious aspect. I anticipate that there's something wrong here. So, which can come only from an observation of his personal information, some of which is beyond the line of duty. Whether he has bought an Audi car or not is not part of the job. But I feel that from fraud prevention, that is a relevant information. Now, how do I bring it into my legitimate interest is through policy, because in my policy, I am going to state that your personal habits, whether you go for foreign trips every year at your expense, is also something which I would like to observe. I may ask you the questions. Why are you traveling so many times and spending so much? Where do you get the resources? Because that is a fraud related query which I have got. And at least Indian law says that information security, fraud prevention is public issue. So you just imagine, when you think, you yourself will understand that what I'm saying is common sense.
Correct. Correct. Yeah.
I have been working in cybercrime area, so fraud prevention, we have been using this sort of information collected from all sources. Only thing is now this privacy law comes and puts a break everywhere.
Right. So I agree with you, Vijay. So to be specific on my request, right? See, when the employee raises a request, I do agree. We are giving a separate agreement for them to sign, mentioning that, how are we using what data we are collecting, what PI we are collecting about the employees, what are we doing with their information, who are they, like background verification. We are sharing the data for the background verification, for legal, for salary processing, all that it's all in the agreement. But the only confusion or challenge that what we are saying is, we need to fulfill the rights of, say, for example, an employee's, right to object, or right to object, processing that data, right to delete. These three rights we are not able to fulfill, because we cannot oblige to do that, because we need their data. Otherwise, we should say they should not be employed. They should resign and go.
No, correct. Say you have to justify that this purpose for which we are collecting is something which is necessary. I cannot pay you salary if you don't give me your bank account number. No.
Correct. So all I'm trying to understand is, can we? We are not able to fulfill these rights. So is that okay?
It is okay. You are saying that there is no right because this information is purpose-oriented collection.
Okay, great.
Correct. Which is necessary to process your,
necessary to process information for the given purpose. Now he has to opt out and say, "Don't pay me salary." Then it's different.
Correct. No, that is better.
That comes in terms of interns and others. No, interns who are working sometimes you don't pay them salary, but you give them access to your company. They are working within the company, so a lot of information there also you would like to restrict, but you are not paying any consideration to him.
Great. So the understanding is these rights cannot be fulfilled, because we will not be able to fulfill our duty if those rights are
No, that is a legitimate interest. The legitimate interest is a lawful basis for processing.
Correct. Because of these two requirements, we will not be able to fulfill those data privacy rights. Okay.
Yeah. So this has to be made clear to the employee.
Okay.
And it requires training. Otherwise, they will read something on the internet and suddenly come and say that I file a case against the company.
So what we'll do, we will update our existing contract with the employee, stating that these are the rights that you can. Say, for example, they have right to look at their information. They'll have the right to update their information. But these rights, like right to delete or right to processing, all that cannot be enabled because of these two reasons: legitimate interest and other one is
we have a legitimate reason. For example, tomorrow if the person leaves also for several years, there may be some kind of a dispute on the raising out of it. So need to keep that information.
So
maybe
Nagendra,
you can put it your case in 3 different buckets. Just my inputs.
Please go ahead.
Before employee onboards, you are going collecting this personal data for various reasons. That is one bucket before onboarding.
Yeah.
While he is an employee with you, that is second bucket, which means for various reasons you have to have this data. We have to process this, whatever the information. That is second bucket.
Yeah.
Third bucket would be when he exited. Again, one more policy, which means, so ideally I'm saying that you can cover in 3 policies, which is before on board, while he's employee with you, and when he exit the employee from your organization. So these 3 buckets, which would cover different policy sets, probably it will help you to
interestingly,
segregate.
Interestingly, Nagendra, what you said is coincidentally happening, but not for the existing. Sorry, first one we are classifying them as candidates.
Okay.
The one we are, with doing employment, right? They are employees, and the third one, ex-employees, we are yet to, figure out the policy. So, but the first 2 buckets are already there. So,
all right then.
Great. Thank you so much, Vijay. And just a follow-up question. Sorry to, my.
Please go ahead.
I hope it helps everyone here. So the second question is, after this audit and defining that retention period, right? So law says that we should not keep it for more than, it is required. Like if it is not required, we should remove. But unfortunately, our management, I mean, I don't know whether I'm open here, but anyway, I can share this. So the management decided to keep the data for infinite period. So this, anyway, I'm not okay with it, but still, this is the management decision saying that, okay, we will not delete, we will continue to have all employee data for infinite period. So what do you feel about this decision?
I say it's a risk absorption decision.
Correct. So what's going to happen? The management should be ready to pay that hefty fine. So
correct. And try to secure it by having say encryption and other things and reduce the risk. But ultimately, if you are the DPO, ensure that this is signed off by the management. You
absolutely. So that
and say this is the best we can do. We can have an encryption, highest encryption. We can archive it. Not keep it in the normal thing. So only few employees will have access to the archive, not all the employees. So those things you can suggest.
Sure. Yeah.
They will have to, for example, there is also a decision. Sometimes a criminal offense happens within the organization.
Correct.
Now, lawfully, you cannot delete that data. Suppose a CCTV footage is there. Somebody has slapped somebody else, and that person has gone to the court. It will take 10 years in the court.
Yeah.
You cannot delete this data. So company may be thinking like that. It's maybe
yes, you are right. You are right. Actually, this is one of the reasons they want to retain the data because say for example, even when they move off the organization, background verification people come and verify with us like certain data. So we cannot just delete it. So we want to hold on the records for our history and other reasons, but maybe we should see what data to be removed and what to be retained. Maybe that we should work.
You have to have a data retention policy in which you write down why it is required and what additional precautions you are taking. And that is the only way you are mitigating the risk. And rest of it, you leave it to either a risk insurance or say absorption.
Great. So the next question, if you're okay, I can, this is about DPIA. I'm sure many are having questions on this area. So currently what I have done on DPIA is like, we have the PI life cycle. First session in DPIA talks about PI life cycle. As Vijay said, like where is the information coming and what are we processing and how it is, what is the next activity? That is PI life cycle. The next session talks about, data privacy rights. Like what are the rights that, we are fulfilling? The next session in DPIA will talk about, are we meeting the data privacy principles? And the next, the third session, it talks about, on what basis we are collecting. So if there are any non-compliance to these 4 divisions, we are identifying that as a data privacy risk, and it will be moved to the data privacy risk register, and we follow that, cycle, like how do we mitigate and all that. So is that a better approach or is this approach effective is my question.
It is also an approach, but there can be a lot more than this because if you include everything which I am discussing as part of the obligation, we have used the word obligations.
Obligation,
so, obligations can be the principal. So if you put all the obligations, including nomination, etc., as principles, it is fine. But if you are looking at principles as only that 5 or 6 things like data minimization, data retention, only those things, then you are leaving out the rest of the obligations.
Absolutely.
Okay,
yeah, after this session, I understood there are so many things, left out. In fact, the grievance, as well, so many things you have mentioned.
Yeah.
So certainly there are a lot of scope of improvement in the DPIA that we are following.
Yeah.
Yeah, I mean, even after inception of about 4 or 5 years of GDPR and other laws, we have been seeing a lot of challenges in implementing this DPA, because the nature of the business or law expectations or requirements there, and also organizational policies and their way of doing the things are changing. So we have been seeing a lot of challenges here too. That's the reason we are trying to arrange this session.
This is Jagannathan, is it?
Okay.
Yes, Jagan. Yes, Jagannathan.
From which organization?
From Happiest Minds, Bangalore.
Oh, okay.
All right.
So we are located in Electronic City and Madiwala being the head office.
Says some
Okay,
of the thoughts which I am giving may not actually be exactly similar to what others may say. So I take pride in saying something which I think is honestly correct. So there can be differences of opinion anyway.
Yeah.
There's one more thing, just a quick clarification. See, currently I play the role of information security as well as the data protection officer here. So what happens now, I'm reporting to the CISO. So again, is it correct to a DPO reporting to CISO? Like, this is just for my understanding, nothing to do with organization, just my awareness sake.
Now, my understanding is that DPO should report directly to the board.
Board of directors.
Yeah, BOD. Yeah.
Okay. Definitely not CISO. Okay.
And what would be the reason, if you would like to justify why it shouldn't happen?
There is a conflict. No, the CISO is looking at information security at present from the technical, both personal and non-personal data.
Right.
DPO is responsible for the public, partly. Part of his duties is the data principles. And he is answerable to the data protection board. CISO is more an internal employee. Okay. So there is a difference. It is better to segregate. In fact, in the GDPR scenario, there has been cases where penalties have been imposed for not segregating the duties. In India, we have still not reached that stage, but the mention is that it should be directly to the board.
Okay, so the understanding what we had is like, since all the data privacy requirements, right? All majority, like all CIA, confidentiality, integrity, or availability, all these controls are coming from security, like information security. So obviously all these are managed by CISO.
Leave aside the DPIA. If you are talking of the entire compliance, business acceptance itself is a risk, which only the board can say. Suppose the vice president marketing comes up with a business this thing, I may reject it as a DPO. I say that the risk here is too much, we cannot accept it. Now that is something which CISO will not be able to take. So that's why if you see here the management responsibilities, say business acceptance policy, business associate policy, these are things which have to be taken care of by the top management.
Right.
Which contract to accept, which have to reject, despite that being profitable, despite it's good from the business angle. That's why CEO also sometimes will look at business from the point of view of my revenue growth or something like that. DPO has to be the brake, accelerate brake. Now people say that the brake actually enables you to drive faster. If there is no brake, you cannot press the accelerator. So you can always justify that sometimes brakes will have to be given. So that's we say management responsibilities include business acceptance policy, business associate policy, regulatory agency relationship policy, how to deal with the regulatory agency, what kind of relationship we have to maintain. These are all things which only the top management can
So in relation to the same question, I'll just put forward one more question here. See, currently when we are signing agreement with our vendors, where our employees PI are shared, say for example a doctor, like we have a lot of employee benefit programs running in the organization where they pull the child care daycare vendors they pull the dentist, they pull everybody. Now there is no control for me to, where this data is running. Like it just goes left, right, center to everybody, all the PI. So, like when I sign, so okay, one control is to put the data protection agreement with my vendors. So that is one of the control I have initiated. But what is happening when I write in the data protection agreement, there is one clause that talks about what are your reasonable technical and organizational control you have put in place. There is one section that talks about it. So for big vendors, yes, like for background verification people, they'll talk about, okay, or, other big vendors, they'll be able to give some justification, right? Like learning development vendor, they'll have some reason they'll give. Technical controls, whatever. But these dentists, these doctors, these child care centers who takes the employees information, they don't have anything. They just have one single laptop. So what control I will expect from them? So in the agreement, this is the challenge I'm facing. I'm not able to put what control.
I understand. Now, whether the processor is big or small, he is either a data processor who has to work as per your contract, or he is a joint data fiduciary. If it's a clinic or something, we expect them to know what is data fiduciary's duties. And in your contract, you please specify what is their role. You please make a mention that so and so is a data fiduciary, so is a joint data fiduciary. Let them check with this DPDPB, and if necessary, you give them a session on DPDPB. But definitely, if you are passing on the information to a small vendor, like one laptop kind of person, you should tell him that you are the processor, you process it, and then afterwards, you please hand over the data to me and delete it or something like that. Or see, that has to be told to them. They will not know.
Okay. So, but technical controls, so you are suggesting you don't need to expect like it's
training of the data processor is the responsibility of the data fiduciary.
Correct. Okay.
This is a typical, third-party risk management, Jagannathan. So you have to roll out from, governance, compliance, audit and assurance. The entire stretch of all the compliance regulatory should be, covered over there, including your security expectations.
Right. That's what our DPA is. The data protection agreement that we signed with a third-party vendor clearly sets out what are the obligations of the third party. But as I said, these small, vendors like single laptop users who are just coming in, providing benefit programs, right? There are employees, basically employees' email ID, employees' mobile number, it's all shared with them. So that is when I was trying to see what technical control I will ask them.
If you can work under a pseudonymization, why should you know whether my employee's name is Suresh or Ramesh? You pseudonymize and give it to him.
Right.
For health, it is possible, but if you are giving his identity like PAN card and other things, it's not possible.
Right. Anyway, so thank you so much. I think a lot of questions are piled up. So please.
You can also bring it under a URM if it is okay. Let's you can put it in the enterprise risk management also.
Okay.
These kind of cases.
Okay. Fine, sir. Thank you so much.
Let's move on. Anybody has any other cases? Sorry, not cases, questions. So there is one question from Saurabh. How will RBI and IRDAI cybersecurity requirements change, and how will other scan copy will impact?
See, RBI and IRDA will be sectoral regulators.
Yeah.
So they will perhaps give some guidelines which becomes due diligence under this act also. Okay. But this law will remain. So the DP board, that is Data Protection Board, will have to have a working relationship with sectoral regulators. Now, if RBI says that data localization is there, that is applicable to that sector. It will not be overridden by this. Okay. So they will, that they have to manage that at the regulators level. Okay.
Each specific sectorial level or regulatory
level.
Yeah. I don't see any other. No, so I don't see any other. So I have one question. If this DPIA is a mandatory expectation by the law, how does it seen in the in court of justice in case any kind of a breach or incident?
Okay.
How will it be treated as?
I have raised this issue in my famous Uma Shankar's case. That reasonable security practices not being followed by the bank is a passive assistance to commission of the crime. And that has been accepted by the court as part of Section 43, subsection G of Information Technology Act. So if there is a guideline from a regulator that you must do something, and if you don't do it, I will actually hold it out as an evidence of negligence in the court. Whether it will be accepted or not, that's a different issue. But in one case, it has been accepted because we were able to convince the court. But to make the court understand there is something called DPIA. If you had done this, it would not have happened. So you have to also prove that. Okay.
All right. Thank you. So this is, I don't see any other questions now. Almost we are coming to the end of session. May I request Manish Kumar to come over, our General Secretary BSPIN, for vote of thanks. Manish, over to you.
Yeah, thank you. I hope I'm audible.
Yeah, you're audible. Yeah. Right.
Thank you for this opportunity to propose the vote of thanks. I think this session, was long awaited, and we have been hearing data privacy, since this GDPR thing kicked off in 2018, and so on, and various countries coming up with their regulatory frameworks. India also, pitching in time and again. I think today's session, was very clear assimilation of thoughts, for us as a practitioner and many of us. I mean, what is identifying the need of doing a data privacy impact assessment, important elements of data privacy that Naavi sir has covered. He spoke about, the data privacy bill, which has been tabled in parliament off and on again, and hopefully something happens this year. His case study that he was explaining on the Divya Drishti company, how things happen, in different geos. And then equally, he spent time on, the consent part, documentations, restrictions, remediation, monitoring, third-party involvement, communication, the involvement of management or leadership, the governance aspect, compliance aspect. He stressed on, the data classification aspect, on the assessment part, retention of the data, enablement, inventory, identity. So I think we all learned, how the data will be gathered, processed, during ensuring this data protection, and various sections in relation to the data protection, the potential impact of non-compliance, he has already covered in this session. Uh, the session also focused on the Digital India Act, which is going for a revision, and it will surface soon. And also he touched through the functions areas which have to be covered during the assessment within the organization. So I thank Naavi sir for an enlightening session on the right way of conducting the data privacy impact assessment. And it was really heartening to see that there were so many questions, and appreciate having multiple mysteries being clarified, mystery areas being clarified this during this discussion. Um, your inputs on various elements related to the data privacy itself, as well as the impact assessment, have been very useful, Navi sir. And the audience may not know, Mr. Navi is one of the pioneer in data privacy within India. And he has mentored many data privacy officers and practitioners, within India, outside India. We have heard him on multiple occasions, and he has taken multiple sessions on this subject. I have heard him in National Law School also, where he goes and teaches to some of the students batches there. And we owe a very special vote of thanks for coming on our forum. Thanks again, Navi sir. I also thank all the participants who have registered. I think this session, after a long time, we have seen many participants coming in. Our registrations went close to 200. Of course, online mode, we only see a 25 to 30% conversion, but yes, a good number of people have joined this session. And thanks to Adi, during the break, he spoke about BSPIN, what we do, and many of people who are new to BSPIN would have known about it. And Last but not the least, a special thanks to Mr. Nagendra to having this, coming up with the concept of this session, interacting with Mr. Naavi, and then getting this session organized on behalf of BSPIN Executive Council. So thanks to all of you once again, and this was really a wonderful session.
Thank you.
Thank you.
All right, so we are in end of the session. Thank you very much. Have a great day ahead.
Thank you. Thank you.
Hopefully, we will coming out with new versions of BSPIN meetings too.
Yeah.
Thank you very much. Have a good day, all of you.
Thank you,
Okay,
sir.
I will close the session. Yeah.
Good day. Bye bye.
Yeah.